Hi everyone, my name is Juliana. I'm the Director of Community Services at the Legal Information Clinic at McGill.
And my name is Alexa. I'm the Director of Communications at the Legal Information Clinic at McGill. This recording is of our Just Info presentation on residential leases during COVID-19, which was originally presented in the context of a community webinar for students hosted by Kirsten Vanderline, the Off-Campus and Commuter Student Support Coordinator at Campus Life and Engagement at McGill, and in partnership with Amanda Rosenberg, the Service Representative at Student Housing and Hospitality Services at McGill. The first part of this webinar, in which Amanda covers helpful recommendations for renting in Montreal during COVID-19, is available for viewing on the McGill Off-Campus and Commuter Student Support website, mcgill.ca/OCCSS.
So before we get into the substance of today's presentation, we just wanted to briefly present our organization and give you an overview of what the clinic does. So the Legal Information Clinic at McGill, also known as the LICM, was founded in 1973 by law students at McGill. The clinic has 3 main branches, and all of our services are free and bilingual in English and French. Our most well-known service is our Legal Information Service, after which the clinic is named. Under our Legal Information branch, the clinic provides answers to McGill University students and Montreal community members' legal questions. Usually we run a phone line, but because of the pandemic, we are now operating remotely. So you can fill out a form on our website, licm.ca, if you have a legal question or concern. After that, a caseworker will contact you shortly to take on your case. However, it is important to keep in mind that because we are just law students and not lawyers, we are not allowed to provide legal advice, only legal information. In other words, we can cite and explain the law to you, but we can't recommend any course of action. We cover almost all areas of law. However, we do not cover criminal law, tax law, or construction, and we can only answer legal questions that fall under Quebec law. If you have a question about one of these areas that we do not cover, though, we are happy to refer you elsewhere. In addition to answering questions, we also have a student advocacy branch that can support you if you have a dispute with the university. So for example, if you're accused of plagiarism, you should contact our student advocacy branch right away. They can advise you on what steps to take and represent you in any hearings with the university. Right now, they are taking on cases remotely via email. Our third branch is community services. We provide 4 main services under this branch. 3 times a year, we set up legal information booths on campus for our Know Your Rights campaign to promote our services to students and to also help them learn more about their housing and employment rights. We also provide a court accompaniment service where we accompany clients to their hearings at the Small Claims Court and the Régie du Logement. However, this program has been temporarily suspended due to COVID-19. Another community service we offer is commissioning oaths. All the directors and senior caseworkers at the LICM are able to commission documents for you for free, and we are offering this service remotely during COVID-19. Lastly, we provide just info presentations, just like this one, to McGill students and community members in order to let people know their rights and responsibilities. It's important to note that just like with our legal information service, we cannot provide any legal advice during these presentations. As such, the LICM provides the presentation for general introductory information only, and nothing in the following recording should be construed as or relied upon as legal advice. In today's presentation, we will discuss the rights and responsibilities of a tenant in Quebec, particularly during the pandemic.
So before we begin, I'm just going to give you a brief overview of what today's presentation will cover. First, I'm going to talk about the Régie du Logement. I'll briefly explain what it is, how to apply, and what measures the Régie has taken during the pandemic. Then Juliana will speak to you about ending a lease, namely ways you can do it and whether COVID-19 has any impact on how you can do so. And lastly, I'll go over a few important reminders about tenant rights and responsibilities more generally, and then I'll go into a bit more detail with regards to the tenant's obligations to pay rent and the landlord's visiting rights, and how these particular situations are impacted by COVID-19. I also want to mention quickly before we begin that all the legal information we're providing you with today is based on articles of law that can be found in the Civil Code of Quebec, the CCQ, which is the law that governs all relations between people and their things in Quebec, including lease of a dwelling contracts. So the Régie du Logement. So we're starting off with this because it's going to come up quite frequently in our presentation, so it's important for everyone who's listening to know what it is. So the Régie du Logement is a special administrative tribunal that was created specifically for residential disputes and is responsible for hearing all disputes between tenants and landlords in Quebec. So for example, if a tenant wants to file a complaint against their landlord because they're refusing to do a repair on the apartment, they would go to the Régie. Or if the landlord and the tenant disagree on how much the rent should be, one of the parties could also go to the Régie to get the rent fixed. So usually you would be able to visit the Régie in person to apply for a hearing if you have a dispute with your landlord. But right now, due to the COVID-19 pandemic, the Régie's offices are exceptionally closed. However, they do maintain a telephone information service as well as their full range of services online, meaning you can still file an application for a hearing right now, but you have to do it on their website. Also, normally, once a tenant files an application to the Régie, they have to send a copy of it to their landlord, and it is recommended that they do so either by registered mail, bailiff, in person with a witness, or in person with a receipt. The point being that they obtain a proof of delivery. However, since for many of us, that is not currently possible due to the pandemic, a copy can be sent either by regular mail or by email, and although there's no proof of delivery, it's going to be presumed that the landlord has received a copy. So hearings during COVID-19. So on March 21st, 2020, it was announced by the Minister of Municipal Affairs and Housing that the Régie du Logement was suspending its hearings until further notice due to the pandemic, that only hearings on matters that pose a risk to a person's health or safety and those involving the issuance of an access order to the dwelling would be maintained, which meant that all repossession of a dwelling or evictions of tenants were suspended unless the landlord had rented the dwelling again before March 17, 2020. However, the Ministry of Municipal Affairs and Housing just announced a few days ago on March 28, 2020, that all hearings would resume remotely as of June 1st, 2020, which is this past Monday. So that means that as of Monday, both evictions and repossessions of hearings for dwellings have resumed.
So now we're going to talk a bit about ending a lease and what that could look like during the pandemic. So normally a lease ends at the end of the fixed term. However, the landlord and the tenant can, via mutual accord, end the lease at any time. Outside of the two parties agreeing, there are only a few circumstances in which the tenant can choose to end the lease early. So first, if the dwelling is no longer habitable and that this is not caused by the tenant. So in other words, it just has become unlivable and unsafe to be there. Second, if the tenant must move to a hospital or a medical center or into low-income housing. And finally, if the spouse of the tenant becomes dangerous and is no longer safe for the tenant to live in the dwelling. So none of these situations are automatic, and they would all involve applying to the Régie and about 1 to 2 months notice. From the landlord's side, there's a couple situations in which the landlord could terminate the lease early. So first, if the tenant has not paid their rent in 3 weeks, or also if the tenant is frequently late in paying their rent. Second, if the tenant hinders the peaceful enjoyment of their neighbors in the building. Third, if the landlord wants to repossess the dwelling for themselves or for a family member. And finally, if the landlord wants to make major renovations. Again, none of these situations are automatic and would still require applying to the Régie. So a lot of people have been wondering if COVID-19 pandemic is a legitimate reason to end the lease early. And this is a complicated situation. So a lot of people have been wondering if this pandemic counts as what's called a force majeure, or in English, superior force. In other words, this is an event beyond your control that makes it impossible to fulfill a contract. So whether something counts as a force majeure is generally decided on a case-by-case basis. It is generally a pretty high bar and only implies if it's truly impossible for a contract to be fulfilled due to an unforeseeable event. There are no hard and fast rules. So for example, COVID-19 might be considered a force majeure in one situation, but not in another. So to give an example to explain that a little further, you can think about how COVID-19 would be considered a force majeure with regards to having to cancel a wedding, as it is now prohibited by law to gather in large groups and therefore no longer possible, but it would likely not be considered a force majeure with regards to the sale of a home, as that is still possible. So with that example, you can see how it's really a case-by-case basis. With regards to your lease, it is likely still going to be considered possible for you to pay rent. Even if you are experiencing financial difficulties, the Régie has said that this is not a legitimate reason for breaking the lease by not paying rent. As long as your landlord has fulfilled their obligation of providing you with the peaceful enjoyment of the premises, it is likely you will in turn be expected to pay rent. So just to summarize, the important considerations for a force majeure are whether the event was completely unforeseeable and whether performance of the contract is truly impossible. If it is still possible for you to pay rent, but you no longer want your lease, you do have a few options which we'll go over now. So if you no longer want your lease, you essentially have 4 options. So the first option is assigning a lease. So assigning a lease is sometimes also called a lease transfer, and this means the person you assign the lease takes over all rights and responsibilities of the lease. So they completely take over any obligations you have. If you want to assign your lease, you need to find someone who wants your lease, and then you must send a notice to your landlord with their name and address. So examples of a notice can be found on the Régie's website, and you can use those examples if you do want to assign your lease. And once you send that notice to your landlord, they have 15 days to respond to the assignment, and they can only deny it if they have a serious reason for doing so. If they do not respond within 15 days, the assignment is presumed to be accepted. There's also a step-by-step guide on how to assign a lease that can be found on the McGill Housing website, which is very helpful. So just on this next slide, you'll see a photo of the notice to assign the lease. So you can find this on the Régie's website, and you would just fill this out and send it to your landlord, and they would have to reply within 15 days. So the next option is subletting. So subletting is a temporary arrangement, meaning your name is still on the lease and you have the right to return to your apartment when the sublease agreement ends. So for example, you could sublease your apartment for September to December if you want to move back in January. If you want to sublet your apartment, as with a lease assignment, you must send a notice to your landlord. And just like a lease assignment, they have to respond within 15 days and can only deny the sublease if they have a serious reason for doing so. It is important to remember that in the case of a sublet, you are still responsible for rent if your sublet does not pay. It's also important to know that a landlord cannot add a clause to your lease saying that sublets are not permitted. It is your right to be able to sublet your lease. So finally, or the third option rather, is that you can negotiate with your landlord. So while we've seen that it's difficult for a tenant to unilaterally decide to end a lease early, it is possible, as we mentioned, if both parties agree to end a lease early. This obviously depends on your relationship with your landlord, but it might be possible to negotiate an early termination of the lease. So it's worth reaching out if this is what you want. And it's just important to remember it's always good to have these agreements in writing. So if you do come to an agreement, to have a record of it. And then finally, the option is not renewing your lease. So with the fall semester being online, a lot of students are not wanting their lease, but it is important to remember that in Quebec, residential leases are automatically renewed on the same terms unless the landlord has taken steps to change the terms. So for example, if the landlord sent to you a notice of a rent increase, or if the tenant notifies the landlord that they are not renewing the lease. So if the tenant wants to leave, they must send their landlord a notice of non-renewal of the lease. And the Régie du Logement, again, has a sample notice available on their website that you can use. So we'll see that photo in the next slide. So this is something you can send to your landlord if you do not want to renew your lease. But on the next slide, you'll see here that there are time limits to when you have to send this notice. So it depends on how long the lease is for. So on this slide, you can see the different time limits for a notice of non-renewal. So it is important to note that with a standard lease of 12 months, you do have to give your landlord between 3 and 6 months notice that you will not be renewing your lease. So on the next slide, we'll just go over a brief situation to clarify some things that have been said. So Dahlia gets a notice asking if she is planning to renew the lease. Does she have to respond? So the sending of a notice regarding the renewal of the lease is not required by law unless a modification of the lease is desired. So for example, if your landlord wants to increase the rent. So that is why, from a legal standpoint, a letter that simply asks the tenant whether or not they wish to stay for another year does not constitute a notice of modification. Therefore, Dahlia is under no obligation to reply. It is important to remember that leases automatically renew, as we just mentioned. So if Dahlia does not want to renew her lease, she does have to give her landlord at least 3 months notice. So for example, if her lease begins on September 1st, Dahlia has to let her landlord know by May 31st if she does not want to renew it.
All right, so now I'm going to go over a few of the most important rights and responsibilities of tenants and landlords and explain how some of these, namely paying rent and visits of the apartment by the landlord, might be affected by the pandemic. So before I discuss paying rent and visiting rights, I just want to go over a few important reminders about tenant rights that are relevant regardless of whether or not there's a pandemic going on. And these are questions that we get quite frequently at the clinic. So first off, and this is a big one, the landlord cannot ask a tenant to pay more than first month's rent upon signing the lease. This means that the landlord can't ask you to pay first and last month's rent or to pay a deposit when you sign your lease. I know that it's common in other Canadian provinces, in Ontario, for example, for the landlord to ask for first and last month's rent, but this is not something that landlords are allowed to do in Quebec. Second, while the landlord is allowed to ask for a tenant's name, their address, a referral from a previous landlord, and a credit check, they are not allowed to ask for their social insurance number, their bank account number, a copy of their driver's license, passport, or health card, or a referral from their employer. And lastly, because this is also a question that we get a lot, people tend to get confused as to who is responsible for what repairs in a leased dwelling. So usually, the landlord has to make all necessary repairs in the dwelling. So meaning that these repairs have to be major. So for example, repairing pipes, electrical installations, or broken doorknobs, things like that would fall on the landlord. However, the tenant is responsible for other minor repairs. So for example, changing a light bulb would be the tenant's responsibility. In some cases, if the situation is urgent and the landlord is aware of the situation and isn't acting, the tenant can make major necessary repairs themselves and spend their own money out of pocket. Then they can then ask the RIGI either for a reduction of rent, an indemnity, or even in some rare cases for a resiliation of the lease. But what is considered urgent is determined on a case-by-case basis by the RIGI. But some example of what they have considered urgent in the past would include major leaks of the pipes or roof, faulty wiring, blocked sewer pipes, rotten stairs or balconies that might give away that lead up to the apartment, furnace breakdowns during the winter, and defects in locks if the lock is the one on the door that gives access to the dwelling. Okay, so now moving on to paying rent. So paying rent is the most important obligation that a tenant has when they enter into a lease. You have to pay your rent and you have to pay it on time. However, because of the pandemic, many people may currently find themselves in situations where paying rent becomes either difficult or impossible. So what happens if you can't pay your rent on time? Well, one of the main consequences of not paying rent is being evicted. If you're 3 weeks late on rent, as Juliana mentioned, or you frequently pay your rent late, your landlord can apply to the RIGI to have you evicted. And while eviction hearings were suspended, they have now resumed, as we've mentioned. And in addition to being evicted, another consequence of not paying your rent is that your landlord can apply to the tribunal to have you pay the missing rent, as well as costs and interest. So it's important to remember that being evicted does not save you from paying the rent that you owe. But we do want to remind students, however, that if you're currently worried about not being able to pay rent, that the McGill has a scholarships and student aid office. They can be contacted all year long for financial assistance, and they've made funds specifically available for people that have urgent financial needs that are caused by the pandemic. So please don't hesitate to contact them. So if you're having financial difficulties due to COVID-19, besides contacting the student aid office, it is important to keep in mind that negotiating with your landlord to secure rent relief is also an option. Obviously, this is dependent on your relationship with your landlord, but especially if someone has a good track record as a tenant, always paying rent on time, no disturbances, it is possible that the landlord will be understanding of the situation and willing to negotiate some sort of rent reduction or deferral. But once again, remember that in accordance with the law and evidence, it's always preferable to put down in writing any type of negotiation with your landlord. But if negotiating doesn't work out, we just want to remind everyone that COVID-19 is not an excuse for not paying the rent. So now just a little situation. So because this happens a lot and because most students will have roommates when they move to Montreal. So this is also a situation that is particularly relevant because McGill has just announced that fall semester will be online. And so it covers the question, well, who's responsible for my roommate's part of the rent? So in this situation, Zoe and Grace signed a lease for a 2-bedroom starting in September. But in September, Zoe moves in, but Grace is staying in Toronto and she doesn't want to pay the rent in Montreal. So is Zoe now responsible for the whole rent? Well, it's going to depend on the lease contract. So if the lease contains a clause stipulating solidarity, so actually I'll just show you a clause right here. So this is the clause on the lease that says the lessee undertakes to be solidarily liable for the lease, yes, no. So if it says yes, that the tenants are solidarily liable, then one of the joint tenants can be sued for the full rent. So that means that the landlord could pursue either Zoe or Grace for the missing rent. But if solidarity is not explicitly mentioned in the lease, then each tenant is only responsible for their own part of the rent. So the landlord would have to go after Grace for her part of the rent. He couldn't go after Zoe if Grace is not paying. Great. So now we're just going to move on to access of the dwelling and visiting rights. So before I speak of how COVID-19 impacts visitation rights, I'm just going to give you a quick rundown of the landlord's right to access the dwelling, whether there's a pandemic or not. So rules surrounding access to your dwelling by the landlord are different depending on whether or not the dwelling is for rent. So during the normal course of a lease, that is, you haven't told your landlord that you're ending the lease or that you're not renewing. Unless there's an emergency, the landlord must give a 24-hour notice. That notice can be verbal or written before entering the dwelling. Once the tenant has been notified, the landlord has a right to visit the dwelling anytime between 7 a.m. and 7 p.m., either to undertake repairs or to verify a condition of the dwelling. And usually the specific reason for the visit will be stated on the notice. However, a 24-hour notice isn't required when the dwelling is up for rent. Indeed, as soon as the landlord receives a tenant's notice that they are ending or not renewing the lease, they have the right to visit the dwelling and the tenant can't refuse them access to the dwelling. However, there are some rules that the landlord must respect when the dwelling is up for rent and being visited. So visits have to take place between 9 a.m. and 9 p.m. and the tenant can demand that themselves or a representative be present. Otherwise, if the landlord doesn't respect these conditions, the tenant has the right to refuse the landlord access to the dwelling. And additionally, the Régie states that it's expected that the landlord and the tenant will come to an agreement on the conditions for visiting the dwelling, and that these rules should be based on logic, common sense, and the principles of courtesy. So this last one is particularly important in this current state of pandemic because, as you can imagine, what was logical and common sense before the pandemic might no longer be, so it might require a revisiting of normal rules of visitation of the dwelling, which actually brings us to our next slide, visiting rights during COVID-19. So now that you know the rights and obligations of the tenant and the landlord when it comes to accessing the dwelling, you might wonder, well, has anything changed now that there's a pandemic? Well, in terms of what's legally enforceable, no. Landlords retain the right to access the dwelling for repairs or with potential future occupants for renting purposes, even during COVID-19. However, the Minister of Municipal Affairs and Housing is asking landlords to avoid visits if possible and to respect a set of sanitary precaution measures when a visit is necessary. And the CORPIQ, which stands for Corporation des Propriétaires Immobiliers du Québec, the Corporation of Quebec Building Owners in English, has endorsed those measures and made additional suggestions to landlords as to how they should handle visits. So first off, the minister has asked that landlords postpone any visits to units where tenants are in isolation due to flu-like symptoms or returning from a trip. But otherwise, if a visit has to take place, the minister has asked that before the visits, landlords share all relevant information on the dwelling with potential candidates and qualify each candidate's needs in order to ensure that to ensure interest and to ensure that there's no unnecessary visits. So for example, if a candidate is requesting that there absolutely be a washer dryer in the unit, but your apartment doesn't have either, then that visit shouldn't be happening. Additionally, the COPIC has suggested that if possible, candidates should complete their rental application and a pre-rental survey online beforehand to reduce the chances of this happening. The minister has also asked that landlords verify that visitors haven't traveled in the last 14 days and that they are not experiencing any flu-like symptoms, and that they have visitors wash or sanitize their hands before entering the dwelling. During the visit, the minister has also asked landlords to limit the number of people, preferably to one visitor at a time, and to limit the length of the visit as much as possible. And that for all those in the dwelling, so ideally would only be the visitor and the landlord, or the visitor, the landlord, and the tenant, that they all keep a distance of at least 2 meters from each other. So respect social distancing rules. And then they've also asked that visitors not touch anything in the dwelling. So when it comes to doing the visit, it should be the landlord that's opening doors, turning on light switches, opening cabinets, all of that stuff. The visitor shouldn't be touching anything. And finally, after the visit, the minister is also asking that landlords disinfect all the handles of all the dwelling's doors. It's also worth mentioning that given the pandemic, the COPIC has asked landlords not to insist if a tenant who fears for their health refuses to allow visits to their dwelling, even though the law allows visits. But these are all just recommendations. Everything I just mentioned, they're not legally binding. So, all right, so that was all from us. We hope that this presentation has been helpful and that you understand your legal rights and obligations as tenants a bit better. Lastly, we just want to leave you with a handful of useful resources. So all the organizations listed on the slides are still providing help or legal information remotely by phone during the pandemic. Particularly helpful right now is the COVID-19 Legal Clinic, which has been set up by the government, and you can call them between 8:30 and 4:30 Monday through Friday for answers to any questions about your rights and obligations during this pandemic. And of course, as we said at the end of the presentation, we have an online form that you can complete on your website if you have any legal questions about housing or any other area of the law.